Hi, everybody, to another week of Samfiru Tumarkin's question and answer session on Facebook and YouTube. My name is Aliya Virani, and I am an employment lawyer at Samfiru Tumarkin's Vancouver office. And I'm going to be here for the next half hour answering all of your employment law questions. So anything to do with your employment relationship, I can help you with. This could be, maybe you've been recently offered a severance package. If there's been recent changes to terms of your employment, maybe the rate or your benefits or your expenses reimbursement, anything to do with your employment is exactly what we specialize in. And so I spend most of my time helping clients who have employment issues resolve those issues. That being said, it is quite a process sometimes to get access to legal advice. There can be a wait time. You can have to, jump through some administrative hoops. And so my firm hosts these sessions so that members of general public can ask me a question or ask questions really by leaving them in the comment box, and then they appear to me in real time, and I can answer them for you so that you can walk away from these sessions with answers to your questions. You don't have to wait. You don't have to sign up for a consultation. You don't have to really just walk away from these sessions, your employment law issues answered. If I don't have any questions, that's certainly going to be the priority, is if somebody leaves me a comment in the comment box. But if I don't get it, we also every Sunday have an employment law show on Global on 980 CKNW. And this Sunday, I was lucky enough to get some information on our employment law show that related to inducement and how that can affect your severance period. And so if I don't get any questions today in the comment box, then what I'm going to do is through some of that information, because it is something that I've noticed has come up with at least 2 or 3 of my clients recently. And so my thinking is that if it's happening to them, maybe it's happening to other people out there. And if I can provide the information that I think would have resolved their claims a little bit faster, or would have been helpful for them to know in the beginning, then maybe I can solve a lot of trouble for people out there. Because that's the goal, is if you have the information, then you can avoid a lot of these problems, or shorten the time that it takes to solve these problems much faster than if you didn't know, because there's a huge power imbalance between the information that employers and employees have, which is why we do these sessions. We're hopefully trying to correct some of that power imbalance. So for anybody who's just tuning in, my name is Aliya Virani. I'm an associate in Samfiru Tumarkin's Vancouver office. And I do see some great questions from people, so I'm into those. A question from Dean from YouTube asks, my employer has told us that we cannot come back to the office with a vaccination. Is this allowed? So very interesting. Now that we are getting to having greater tranches or groups of the general public register and receive their vaccine, returning to work seems like something that is being discussed between employees. And of course, a very question will be, what are your rights to refuse going into work? What are entitlements to force you to come into work? And under what conditions are you allowed to do that or not do that? And so in the context of the vaccination as well, it's been, I think a lot of people want to know, can your employer force you to take it? If you have been working from home already and your employer has allowed you to do that, and it's the requirement for going into the workplace, then they may be able to get that vaccination before you go into work. And I know it may not be the answer that you want to hear, but it's better to know really the best quality information possible so that you know how to navigate the situation. And it never hurts to have an open and honest conversation with your employer. Ask them if you can continue from home, if that has been something that they've allowed you to do in the past, if you don't want to get the vaccine. Because right now there is no law that mandates that you have to get the vaccine, or that allows your employer to force you to get the vaccine. They can strongly encourage it. And employers do have a duty to provide a healthy and safe working environment to their employees. And they may also have to follow certain rules about how they operate in terms of following public health orders and WorkSafe BC law in terms of what's best practices is set out by WorkSafe BC. And it is plausible, or it is possible that those laws to operate in a healthy and safe working environment include making strong recommendations that employees get the vaccine. There's going to be certain exemptions with people who have onto certain protected grounds under the Human Rights Code that aren't going to be required to get vaccinated, or that the employer has to be very careful about making that recommendation. And in fact, I'd say best practices for the employer would be not to recommend that certain people who have protected grounds under the code get that vaccination. But for everyone else, they can make that recommendation. They can, make that a condition for coming back into the office if it's not discriminatory. Like I said, in turn, if they can accommodate you at home and you have been working from home, there's really no reason I'd say that the employer can't do that or can't continue to do that. And so, working from home was a temporary measure for the purposes of COVID. And now that COVID has an end in sight, it's not improper for your employer to say, well, let's return back to what we used to do before. If they decide to terminate you over this, then it has to be upon providing you your fair amount of severance, and it would also have to be something that they make a very careful decision about, because it shouldn't be seen, as like a punishment for you not getting the vaccine in some way. But if that's, say, related to political belief, because that is, again, one of the protected grounds under the Human Rights Code, at least in BC, it's different province. So I say the short answer, Nadine, is that it would help to have an honest and open conversation with your employer as a starting point and see if they can accommodate you working from home as potentially you have been doing. I'm making an assumption that you have been working from home if the request now is to come into the office. And if they are firm on that point and you don't want to get vaccinated, then the ability to require people to office, and that may be that they have to make certain accommodations for you in the office where maybe you're separated from other people. It may not be, it's certainly not appropriate for them to require you to get the vaccine, but they may be able to, or may be allowed to, under WorkSafe and Provider rules, have you work in the office unvaccinated in certain conditions so that you're separated, for example, and that would be within their rights. But it's certainly not within any employer's rights right now, unless the legislation changes because of COVID, to require you to get a vaccine in order to keep working. So I hope that helps. Very, it's a tricky issue. It has to do with, one is, what's the ability to, what are the rules around ending working from home or working back in the office possibility? And what are my rights surrounding it and my employer's ability to work under certain conditions? So very topical in the context of the pandemic, certainly an issue that we come across on a daily basis. And it's a great cross-cutting question that has allowed me to hopefully provide some people who may be dealing with one of those three different issues. So I have a question now from Kat. Kat asks, can you still help with disability issues if we have a union, or does that matter because it's with an insurance company the benefits are from? So all different issues here. I think the short answer I say is that if you are unionized, it's going to affect we have an employment group at Samfiru, Tumarkin, and we also have a long-term disability group of lawyers who can help with, your disability insurer coverage. So your issue kind of, it seems at first like it would involve both of them, but I truly think that you're dealing with a long-term disability insurer and maybe a coverage issue. And that may not matter if you're in a union or not. I'm the employment law group in Vancouver, and we do have long-term disability associates who practice in that type of law. And if it is a long-term disability issue, then I'd encourage you to reach out to them because they're going to know a little bit more about that area of law. It doesn't necessarily matter that it's with an insurer. That's exactly the type of claim that they would deal with. but I'm not able to tell if the fact that you're unionized would affect that. Because generally speaking, for employment law issues, not just in BC, but across our country, if you do belong to a union, you're going to be governed by what's called a collective agreement. And a collective agreement is kind of like a master employment contract that sets out all of the rights and obligations between the employer and the employee in that, or which is your union. Private counsel, like employment lawyers like myself or anybody at my firm, we can't step in on behalf of a unionized employee to make changes to that collective agreement. So it's going to be an issue from the employment side, say if you're looking for severance or that type of issue. But if it's potentially related to your long-term disability coverage, maybe it doesn't matter that you're in a union. I'm not going to be able to tell you definitively because that's not the area of law that I practice. But the good news is there are lots of lawyers that, that are my colleagues at Samfiru Tumarkin that practice in long-term claims and appeals, and they will be able to help you with this and tell you if that union issue is going to be a claim issue, and give you some guidance on that. And the way you can reach out to them is if you go to our website, which is www.stlawyers.ca. There's going to be a contact us form, and you can write exactly what you wrote here would be perfect, and some of your contact details. And then somebody from our intake team can reach out to you and set you up an associate that will be from our long-term disability. And then they can go through those issues with you and give you some appropriate information that can answer your question. But I hope that this kind of overview gives you an idea of how to signpost what issues could come up so that you're better prepared for that appointment and you can really make the most of your time. That's a fantastic piece of advice I think I could have for anybody, is that the more you can educate, really the better equipped you are to deal with these types of issues with your employer. Or if you ever need legal advice, you can make the most of your time getting that advice, because it can sometimes be costly, and really the more informed that you are, the better protection you have for your rights. And so you can hire an advocate or you can be your own advocate. And the idea is that if you have a mix of both, if you need it, then you're really positioned to be in the best chance of success. One of the ways that you can get a little bit more information is by going to pocketemploymentlawyer.ca. We put out a ton of information about different employment law issues and how to solve them, or how to recognize them and what you can do about it, and your options to check out if you're curious about employment law in general. Or otherwise, feel free to tune into our Sunday 4 p.m. show on 980 CKNW. We go through a lot of popular employment law topics, in addition to having these Facebook Live sessions. So I see a couple more questions from YouTube, and one of them is from Puneet. I think, Puneet, you might have left a very brief question last time, so I'm happy to see you again. And this time, Puneet is asking, my manager has been extremely rude and insulting via messages to create a hostile environment. As a result, I have stopped using the company's messenger tool. Is this considered harassment? Well, I'm sorry to hear that. It certainly can. That does sound like harassment. You're not supposed to be insulted and treated rudely by your employer. Really doesn't matter if it's over messenger or in person. I'd say that the benefit, not that there's really, but the silver lining here is that if it's through a messenger app, I would save those messages so that you have a record of what's been happening, because a lot of times there is bullying and harassment. It's difficult to prove because it's been done in person or it's over a conversation. And so one of the things that you can do here is show that it's been happening for the period of time that's happening, when it's happening, in the context, and you have that kind of snapshot already in this messenger app. And particularly if you think that you're going to be terminated, it may be a good idea to save this before anything happens to your employment, because if you're let go and it's a company-run messenger tool, you may not always have access to these messages. So I would just say that now that you know that this is happening and you're aware of what's going on, maybe to save them as soon as possible. If you have been experiencing bullying and harassment at work by your employer, then that can form the basis of what's known as a, and I see, Praneet, you're just letting me know you've saved those communications. HR agreed it was unprofessional from your manager, and that's about it. I want to make about that. One is that HR is it is a person that is hired by your employer to, honestly, most times protect your employer. And so you may feel like HR is not on your side, because they're not. They're there to, they're not necessarily there always to resolve issues in your favor. They're there to resolve issues before it becomes a problem for your employer. And so that's the difference between, it's always best to go to HR and make sure that you have a formal record of that. But if you can't be your own advocate to do, you're able to do a mix of both. And it sounds like you've taken some great steps to bring it to their attention. I'm not surprised that they're not doing, enough to solve it. Fortunately, I see the result of issues every day. So that could just be by virtue of the position that I'm in. But, the fact that HR has agreed it's unprofessional, I think, speaks volumes. So it sounds like you could have a fantastic basis for a constructive dismissal complaint. And if you're inclined to leave that position, then what you can do is essentially let your manager or your employer know that you're not willing to tolerate the treatment that they've been essentially acting, the way that they've been acting towards you. You're not going to tolerate that from them any longer. And you're going to consider your employment terminated, because it's an essential term of your employment, whether it's written into an agreement or it's implied without an agreement. You're not going to be bullied and harassed at work. And you are entitled to a workplace that's free from violence, discrimination, and bullying. You have a couple of different options here. You can make a complaint to WorkSafe BC. In some cases, you may be required to do that first. If the communication is inappropriate on one of the protected grounds under the Human Rights Code, then you can certainly make a Human Rights Tribunal complaint. In addition to what we do, which is, well, we can help with either of those things. But, a big part of what we do is we take complaints of bullying and harassment very seriously. And we essentially help employees leave their places of employment when that's been happening and still collect their severance, because ideally these employees want to resign. And of course, if you resign, you don't get any severance. But in those circumstances, you can see it's not very fair. You're not maybe leaving on your own free will. You're being forced to resign because of the work environment. It's a toxic work environment. And so you should be penalized for that. So it's a great first step that you've done. You've done exactly what I would recommend one of my clients do if they were to call in, which is to take photos of the message and to make a complaint to HR. I would ensure that the situation was read by the HR department, just to make, be absolutely crystal clear on that. And then you may want to consider seeking legal counsel to get your severance entitlement if you find that the WorkSafe BC route and maybe self-representation is not for you. We're happy to help with this. So again, wants to retain us to help with, being essentially their advocate for the actual legal claim. If unfortunately it does come to that, then you can reach at, again, www.stlawyers.ca, the contact us fin, and your name, and we'll be able to contact you and kind of guide you through the next steps and the overview and the process for a claim, how it can be resolved, and what you can expect. But again, the idea is that through these sessions, hopefully I can provide enough information to people who are experiencing issues early on, or maybe before they even start, and help them so that you don't need to go through that long drawn-out process. Unfortunately, if it happens, you want to know what you can do about it and who you can get help from. And of course, you're always welcome to contact us, and that's exactly what we do. This is our specialty. We're to help with it. I do it every day. And so if you want somebody who's qualified to act as an advocate for you, we are more than happy to do that. If the unfortunate situation comes up that you do need to bring a formal claim. So I have a question now from Tanya, and Tanya asks a good EI question. Can my employer let me go when I come back from EI because this was a forced leave? My husband is a truck driver and he goes to the US. Do I lose severance pay if they let me go when I come back? I'm assuming this, well, I don't know exactly. There's a couple of different types of EI that you can be on. And if your employer, if you still have a job protected leave while you're receiving EI benefits, then I'm assuming it's either going to be a medical benefit provision or a maternity leave provision or bereavement leave, compassionate care leave. There's certain benefits that can be provided where your job is still held open for you. If it's, regular EI benefits, that's a situation where you've been let go. And so I'm assuming that that's not the case because you've made a reference to your employer requiring you, or, can your employer let you go when you come back from EI? So there's assumption that you're going to come back from EI. But it certainly helps if I have a little bit more information, because otherwise I'm left with making assumptions and I don't want to do that. But what I can tell about these types of job protected leaves with EI is that your employment continues to run. And so what that means is that, any wage increases, any benefits that you would be entitled to while you're on these EI job protected leaves, your employer has to continue providing those to you. And so I think your question, do I lose severance pay if they let me go when I come back? No, you would have that period of time counted towards your years of service that is used as a determination of the severance that you receive. Not only your statutory severance, but your full and complete severance entitlement, which is your common law severance. And so the short answer is that, just by virtue of you being on one of the job protected leaves or the EI benefits provisions doesn't mean that your severance is going to be affected. And if it is affected, then you could be wrongfully dismissed. And so just because I'm saying all of these things that your employer should be doing, it doesn't always mean that that's the case. They don't always do what they're supposed to do, although we would want them to. And so don't take their word for it. It's great that you're reaching out and, informing yourself, because nobody is going to be an advocate for your own interests like you will be. Your employer is going to be an advocate for their interests. That's just sometimes how it works. So, and I know that because I see the many claims that come across my desk because, an employer's told an employee that something is the case when it's really not. So make sure that you know that when you do come back from your EI protected leave, that one, your job is waiting for you. They may be entitled to hire somebody in your absence, but when you come back, they must return you to that position or a similar position. And if they do let you go without cause, they're entitled to your full severance and not to accept anything less. That's going to include at least your statutory minimum severance under the Employment Standards Act. But don't let you that that's all the severance that you must be provided. A lot of times, most of the time, it's a lot more. And so really ensure that you've had that severance package reviewed so that you're not being shortchanged on your entitlement when you're terminated, because especially during COVID, it's really important to have that financial buffer so that you have time to look for work without worrying about your finances. So I just have about 1 minute left, although I started a little bit late today. So I want to complete, I want to answer as many questions as possible. And so I have a question from Antoinette from YouTube, and I'm going to make sure that I get the full answer to you, Antoinette. And she says, hi there, I'm being bullied and harassed in work, but just waiting for them to let me go as they are being very negative to me. So it looks like you're having some sort of physical effect from the bullying. That's, it's understandable. A lot of times you can have health concerns that relate to being mistreated at work because you spend a lot of time there, and it does have a significant impact. Again, I don't know if you were able to hear my answer when I was going through the options for bullying and harassment with the previous question, but the answer is going to be more or less the same, in the sense that you want to make sure, I think it was Puneet's question, you want to make sure that you bring this up to HR. If they have an HR department, they're supposed to have a proper policy for dealing with bullying and harassment. If they don't, you want to make that complaint to WorkSafe BC, because WorkSafe BC mandates lawyers in this province have a proper system for dealing with bullying and harassment. And if they don't, then they can be cited by WorkSafe BC and fined. And then depending on the type of bullying and harassment, if it's discriminatory, you can make a BC Human Rights Tribunal complaint. Or otherwise, what I would do, I think in your situation as an employment lawyer, I would, I see you're saying you're signed a policy. So they do have a bullying and harassment policy. Then you can explicitly point it out to them that they're not following this policy. So even more reason they can't say that they were unaware, although an employer not being aware of what constitutes bullying and harassment under either the Human Rights Code or our common law is not going to be a defense. There's some fantastic tribunal decisions that comment on an employer's ignorance not being a defense to the fact that they have decided to bully and harass. But even more so in your situation, Antoinette, you can point out that they have a policy against exactly the type of behavior that they're engaging in. And so, I mean, you don't really need to point to that to show that it's wrong. It's simply wrong. You know, you're not supposed to be bullied and harassed at work by your employer. It's just simply not within their rights, and you do not have any obligation to accept that. You can make what's known as a constructive dismissal claim. Again, like I said out before with Puneet, but in your case, what I would mention is that because you have let me know that you have experienced medical side effects, or you have, you know, your legs hurt because of you said your legs are all sore because of bullying, then it will support what's known as an aggravated damages claim. And that is something that you can, a type of claim that you can make when you have some medical harm. And so you want to be careful with how you make that claim. You are making a WorkSafe BC claim at the same time for mental distress injuries. But it sounds like there's going to be enough of a separation there. And there, like I said, if you do want help making these types of claims, you're more than welcome to reach out to me. I'd be happy to help you with this. I would strongly recommend you making an aggravated damages claim, because what that can do is cover, say, the cost of physiotherapy. It can cover any out-of-pocket expenses. Maybe you've had to get hot and cold cooling pads or something like this, you know, for maybe helping with the muscle soreness in your legs. Maybe you've had to buy some sort of prescription receipts or go to your doctor. If you can get a note that supports that or explains why you are experiencing those symptoms and that they are work-related, then you can make that claim and seek reimbursement for essentially the trouble and the harm that you've been caused, not just your out-of-pocket expenses, but, you know, for an award of compensation, because that's how our court system works, is they compensate you for a legal wrong that's been committed against you, because you have, you know, suffered that effect at the hands of your employer. They need to not act that way. And if they do, then you do have remedies that you can request from our court system. There are protections that you have, and there are options that you can take advantage of in order to correct that power imbalance, because that's not behavior that you're required to tolerate. And I'm sorry to hear that you're going through this. So again, if anybody wants to reach out to us, I'm happy to help with these types of issues. I hope that I've given some sort of at least general information for where you can look and what you can do if you are in these types of situations. But again, pocketemploymentlawyer.ca is a fantastic educational resource. Even going on our website at www.stlawyers.ca, we comment on news articles. We have even previous employment law shows. This upcoming Sunday, we're going to have another employment law show on Global. I'd strongly encourage everyone to, you know, listen in and educate themselves and really prepare yourself and arm yourself to be your own best advocate in case these issues come up and you didn't get a chance perhaps to ask the question today. So understandably, you may not want to make this public, but feel free to reach out to us privately, or otherwise you can catch us at our next Facebook Live and YouTube question and answer session. So these, Antoinette, I see just one last question. For anybody who's tuning in, you can rewatch these live sessions. You won't be able to ask questions live because the live period will have passed. So we won't be answering them, you know, in real time anymore. So you can ask them at the next live session, or otherwise you can rewind. This will be on our Facebook page and available on our YouTube site, so that you can rewatch any of the previous YouTube and Facebook live question and answer sessions, and you know, pause them, write down notes, whatever you need to do. So I hope this has been helpful. Thank you again, everybody, for